So we're back with a bonus episode. We will be releasing short 5 to 10 minute episodes from time to time, updating our listeners on developments related to prior full-length episodes or any current events we think will be interesting to our audience.
So for those of you who remember the last episode, we were here with the journalist Felix Salmon talking about the saga of the Berkshire Museum and its attempt to deaccession 40 of its most valuable works of art. And there have been some developments that we want to tell you about.
The Attorney General of Massachusetts and the Berkshire Museum came to an agreement, basically, about the sale of the 40 works of art from the Berkshire Museum's permanent collection, whereby they agreed to go to the Supreme Court and ask the Supreme Court's permission to apply two equitable doctrines called deviation and cypre to the sale of these works. The museum did not admit that they couldn't sell these works unrestricted anyway, but they said even if we can't, even if there are restrictions, the court should intervene and waive those restrictions because we really need to sell these works of art to support ourselves and to build an endowment so the museum doesn't go under. And they filed a petition with the Supreme Court saying that, and the Attorney General did not oppose that in light of the specific requirements for the sale that the museum proposed.
So just to be clear, the Supreme Court that you're referring to is the Supreme Judicial Court of Massachusetts.
Right.
And it's the highest court in the state of Massachusetts. And it's a little bit unusual to have the Supreme Court of Massachusetts or the highest court in any state hear what's essentially a case in the first instance, which is what's being done here.
Yeah, and we should add that the two appeals that we told our listeners about in our full-length episode are still ongoing. The appeals from the Rockwell brothers case and the members of the museum case, those two separate litigations, are still up on appeal in the appellate division, which is the division below the Supreme Court. Those cases haven't gone away. What we understand from lawyers working on this case is that those plaintiffs have been given permission to file amicus briefs in the Supreme Judicial Court to make comments on the AG and museum's joint proposal or petition. They are opposing that compromise. They still don't want the sale to go forward, but that doesn't moot their appeals. Their appeals are still on the docket in the court below, so it remains to be seen whether the Supreme Court will bring those appeals up or if they'll somehow be consolidated. We should say that the Rockwell brothers, not all plaintiffs in the Rockwell case, the Rockwell brothers dropped out, and they dropped out of the case because the terms of the compromise between the AG and the museum were satisfactory to them. Steve, do you want to
Well, I think I would just add a little sidebar on this ancient doctrine of cypre. Cypre is from the Norman French cypre comme possible, as near as possible. And it's an equitable doctrine that has been fashioned by courts for hundreds of years to try to deal with situations where somebody gives something to a charitable institution and expresses an intent that their gift be used for a particular charitable purpose, and then something happens along the way to make that impossible. And this really first came into existence in the Middle Ages, and particularly in England under Henry VIII, when a lot of the institutions connected to the Catholic Church began to be dismembered. So over the years, it has been used, for example, to redirect money that may have been used prior to the abolition of slavery in this country. There were organizations that were established to promote the abolition of slavery. Once that happened, those funds and those institutions had to be changed. And the way you do that is you go to court and you ask the court to exercise its equitable jurisdiction under the doctrine of cypre. Another variation of cypre is called deviation, which is also one of the remedies here, which the museum is seeking, and that the Attorney General, I guess, is endorsing. But unlike cypre, which deals with trying to match a donative intent with a situation that's become impossible, deviation usually deals with restrictions that have been placed on gifts that also are being asked to be removed for various reasons of either impracticality or impossibility. And in this case, these would be the restrictions that certain gifts that were given before the museum was founded and that were given to the Athenaeum, as we discussed in the last podcast, that those restrictions are alleged to prohibit any of those objects from leaving the Berkshires.
Right, there's a statutory restriction, and then maybe Norman Rockwell restricted his gift of these two famous paintings in the 50s and 60s.
And at least in terms of the petition that has now been filed by the museum with the Supreme Judicial Court of Massachusetts, the museum has indicated that the Attorney General still is of the belief that these restrictions apply to some of the works in the collection, and therefore they're asking the court to either exercise the equitable relief of cypre or deviation in order to allow the sale of these objects to happen.
They basically agree to disagree, and then they come to a compromise.
Right.
So what's that compromise, Steve?
Well, some of the compromise seems a little bit murky, but the centerpiece of it seems to be that both the museum and the Attorney General have agreed that Rockwell Shuffleton's Barbershop,
The most famous work at issue in this whole controversy.
there is an indication that another museum has made an offer for this work. It's not disclosed in the petition which museum that is, and it's not disclosed how much that museum is offering to pay for it. But there are some conditions that are put on the sale to the museum, which include a loan to the Rockwell Museum and some promise that the work will be displayed publicly in the Berkshires for some amount of time, and then will also be on display in public at an undisclosed location. We're presuming it's a United States institution because it's described as a 501c3 charitable institution.
The AG and the museum have also agreed to cap the amount the museum can receive through the sale of these 40 works at $55 million. That includes the Shuffleton Barbershop sale, whatever that is for. So after Shuffleton gets sold, the museum can then arrange in 3 tranches different groups of the rest of the works, the 39 works that are remaining. And they will style the first tranche of works to go up for sale through Sotheby's in order to meet the difference between the amount of the sale of Shuffleton Barbershop and $55 million. So they're allowed to bridge that gap, and they're going to do it in baby steps. So they're going to sell one group of art to try to get there, but no more than is necessary to get to $55 million. And if they don't reach the goal in that group, they can sell one more group of works in order to get to $55 million. And if that doesn't work, there's a third group, and they can sell that to get to $55 million. The proceeds are restricted in the following way. So the museum can use $50 million of that $55 million in an unrestricted manner for capital costs, renovations, its new vision plan, whatever it wants, as long as it meets the museum's general charitable purpose. That extra $5 million can only be used to benefit the museum's collection, acquiring new works or taking care of works, and that can be works in the science or natural history exhibits, not just art. If, in the sale of one of these tranches, the museum takes in more than $55 million, then that excess above $55 million can only be used for the art collection, to acquire works of art or to care for existing works of art. So that's the scheme under which the museum and the AG have come to an agreement. So, Steve, who gets to decide what's in these tranches? Is that clear in the petition?
Yes. Well, first of all, let's just talk about the word tranche, which seems to have migrated itself into this particular petition that was filed with the court. We associate tranches usually with financial instruments and other types of things, but really what we're talking about are 3 groups of works of art.
Tranche is a fancy word for group.
Right. So it's very clear that the Attorney General is signing on to a plan that gives the museum's board complete discretion to decide what is going to be in each tranche, what price to sell works at, and what order to sell them at. And as long as the museum proceeds along the lines that you just outlined, Katie, the Attorney General is going to take a very hands-off approach to this.
So why did the Attorney General change his mind, Steve? I mean, we talked in the last episode about the fact they filed this lengthy court filing asking for a preliminary injunction setting forth, several merits-based arguments why the museum wasn't allowed to sell this work, including insinuating that the museum really didn't need the money.
Well, that's a hard question to answer, and the petition, which was filed by the museum, doesn't shine a lot of light on it. I think one conclusion that we can reach is that the Attorney General, after conducting its investigation, at least agrees with the museum that they are in serious financial difficulty and that this is perhaps the only way out. The problem that I have with this deal, and the problem that I've had all along, apart from the ethics of whether or not a museum should deaccession its major works, is really the lack of transparency, and that's one of the things that we spoke about with Felix.
And it is still the case here.
We still know very little. We don't know which museum is buying the work. We don't know how much it's being purchased for. The only thing we know is that the museum is now seeking permission with the consent of the Attorney General to sell 40 of its most valuable works in its collection.
The AG's stated reason for agreeing is that somehow through their year-long investigation and interviews and document collection, they've come to the conclusion that the museum is in as bad financial shape as they say they are.
So I guess this means if in fact the museum is successful, it does give a green light to two museums, at least ones in Massachusetts, to consider using its art collection as an asset.
Yep. The court still has to approve this deal, and they may or may not. We don't know what's going to happen to the two appeals still pending in the appellate division below the Supreme Judicial Court, so we will keep you posted.